Pull up your property deed. Find the legal description, the part that reads like bureaucratic poetry, all sections and townships and ranges. It will say something like, the northwest quarter of Section 14, Township 7 North, Range 4 East, according to the United States Public Land Survey. It will cite a survey. What it will not tell you is who actually stood on your land and drove that corner marker into the ground, or whether anyone ever did, or whether the field notes from that original survey, the handwritten record of where the man with the transit and the Gunter's chain walked and what he measured, were ever independently verified against what was filed in Washington. It is a document that promises, implicitly, that someone with professional credentials and legal accountability stood between you and uncertainty and resolved it. I spent 6 months trying to answer whether that promise was kept. I checked every finding 3 times before I said it out loud. What I found is going to shift something you did not know you were standing on. The Public Land Survey System was created by the Land Ordinance of 1785. The design was genuinely radical. Divide the entire territory of the United States into a uniform grid. Township 6 miles square. 36 sections of 1 mile square inside each township. Every corner permanently marked. Every boundary line measured by chain and compass. Every measurement recorded in a field notebook deposited with the General Land Office and available to any member of the public who wanted to check it. Look, the original system was not designed to be taken on faith. It was designed so that a farmer in Ohio in 1810 could walk into his county land office, pull the original field notes filed by the deputy surveyor who walked his section, and confirm for himself that his corner marker was exactly where the survey said it was. Accountability was not incidental to the design. It was the entire point. The people who wrote that ordinance had spent years watching British land grants generate overlapping, unverifiable, litigation-breeding chaos. The PLSS was a system deliberately engineered to make large-scale fraud structurally difficult. That is what makes what happened next so precisely, documentably devastating. By the 1880s, the federal government was contracting out the survey of the American West to private deputy surveyors paid by the mile. Not by accuracy, by the mile. Survey more miles, receive more money. The incentive structure was not subtle. Under the revised statutes of 1878, the General Land Office was supposed to independently verify a percentage of those surveys through field inspection. Send a government examiner to walk a sample of the lines, check the corners, compare the field notes against the actual ground. In practice, the inspection regime had collapsed under the volume of claims flooding in from California, Oregon, Washington, and the territories. Field supervisors were overwhelmed. Independent verification became, in most cases, a signature on a form rather than a pair of boots on the ground. The examination that was supposed to catch fabricated work became the last thing the system could reliably provide. And into that structural gap, into that quiet collapse of the accountability the system had been designed to provide, walked a man named Salmon P. Benson. The Benson Syndicate. Write that down. This is not colorful historical background. This is the foundational corruption that the 1909 legislation was built directly on top of, without addressing it, without correcting it, without ever telling the families whose property lines traced back to Benson's surveys that anything had gone wrong. Between approximately 1878 and 1887, Benson and his associates filed surveys for roughly 20 million acres of California land, an area larger than the entire state of South Carolina. A significant portion were fabricated, not imprecise, not the result of poor technique or inadequate equipment, fabricated from a desk. Field notes describing careful, methodical measurement of terrain that the surveyor filing them had never walked. Corners described as set in ground that investigators later established was buried under several feet of snow on the alleged survey dates, rendering those dates a physical impossibility because no human being could have been on that land when the notes claimed. Rivers recorded on official federal plats running 2 miles from where they actually ran. Section corners marked at specific grid intersections where field investigators found no monument, no blazed witness trees, no chiseled bearing trees, no evidence of any human presence. A federal grand jury in San Francisco examined the evidence and returned 41 indictments. 41. Benson himself was tried. And this is the part that I cannot get out of my head, the part I kept returning to in the archive. Not one conviction was obtained. Not one. The prosecutions collapsed primarily on procedural grounds. The fraudulent surveys remained in the General Land Office's official record, uncorrected, as valid federal surveys. No correction order was ever issued for the affected townships. No notice was sent to landowners whose property descriptions referenced those surveys. The lines Benson's men wrote down without ever standing on the land remained the legal basis for property descriptions across millions of California acres for decades after the fraud was documented, prosecuted, and then quietly allowed to disappear. You think anyone told the homesteaders in Shasta County whose claims were filed in 1882 that the survey their deed traced back to had been indicted in federal court? The families who built houses and strung fence lines and dug irrigation channels in Fresno and Tulare and Tehama counties. They passed land to their children and to their children's children, based on descriptions that the federal government's own investigators had established were, in a material number of cases, fiction. There was no process for telling them. There was no mechanism for correction. There was nothing. And right, here is the thing. All of this was known. It was documented. It was sitting in the records of the General Land Office, in Record Group 49 at the National Archives, where it still sits today. What happened next is not the story of a fraud that was discovered and corrected. It is the story of a fraud that was acknowledged, prosecuted unsuccessfully, and then buried by legislation that gave the federal government authority over the very boundaries the fraud had corrupted, with no requirement to first identify which boundaries were fraudulent before exercising that authority. Between 1909 and 1910, the 61st Congress passed 4 pieces of legislation that restructured who held authority over the original survey system. The Resurvey Act of 1909, the Pickett Act of 1910, 2 additional administrative reorganization measures. Together, they transferred oversight of public land surveys from state surveyors general, locally accountable, locally familiar with the terrain and the specific history of surveys in their states, to a centralized federal apparatus under the direct authority of the Secretary of the Interior. 15 months, 4 laws. The accountability structure the Land Ordinance of 1785 had deliberately built in: local verification, state oversight, the chain of custody from the man in the field to the public record, dismantled and replaced with top-down federal authority answering to one official. I checked this against the congressional record of the 61st Congress before I said it. The debate is there. The vote tallies are there, now. The Secretary of the Interior who received this consolidated authority, the single official who now held the power to reestablish property corners across the American West, in states where the original surveys had been established as fraudulent, was Richard A. Ballinger. And just so we are clear about the timing, Ballinger had, immediately before his appointment as Secretary under President Taft, been the private attorney of record for the Cunningham coal claims. 33 claims in the Bering River coalfield of Alaska, held by Clarence Cunningham on behalf of investors that government investigators had connected to J.P. Morgan's banking house and the Guggenheim family's mining syndicate, the Morgan-Guggenheim Syndicate, which had already consolidated control over significant Alaskan copper extraction and was positioned to do the same with coal. Ballinger had personally reviewed those claims on behalf of the claimants, in his capacity as their private attorney, concluded they were in compliance with federal law, and then became the federal official responsible for deciding whether those same claims were valid. He cleared them as a private attorney. Then he became secretary. Then Congress gave him authority over the resurvey of the public lands, meaning the authority to decide, in the states where Benson's men had filed fabricated field notes for land they never walked, which corners were valid and which needed to be reestablished, which, as we have covered when discussing the government's established relationship with survey accuracy, was apparently still a negotiable concept. Louis Glavis was a General Land Office field investigator who had spent 2 years building an evidentiary case against the Cunningham claims. He brought his findings to Gifford Pinchot. chief of the Forest Service and the most prominent conservationist in the federal government, because he believed the Interior Department under Ballinger was suppressing the investigation rather than acting on it. Pinchot brought the matter to President Taft. Taft reviewed it and, in November of 1909, authorized Ballinger to dismiss Glavis from federal service for insubordination, documented in the official record. Pinchot then wrote, unsolicited, directly to a Senate committee, stating in writing that Ballinger had systematically undermined public land conservation policy in the service of private corporate interests. Taft fired Pinchot in January of 1910. The only senior federal official actively and publicly opposing the consolidation of land management authority under a secretary with documented conflicts of interest was removed from government within 14 months of Ballinger taking office. Collier's magazine published the full account, with documents, in November of 1909. A congressional investigation followed. The result is House Report 358, 61st Congress, a party-line exoneration, with a minority dissent documenting exactly which evidence the majority declined to consider. It is in the archive. Read both. If you're still here and you haven't walked outside to look at your property corners, hit subscribe, because we go much deeper on this every single week, which somehow is not the worst part. The worst part is 1926. By then, the General Land Office had accumulated decades of homestead contest case files, the administrative record of every formal dispute between a private land claimant and the federal government over a public land entry. These files contained original survey field notes, field examiner reports, testimony from witnesses who had physically stood on the disputed land, and the government's own internal assessments of whether the underlying surveys in specific townships were accurate. In a number of cases, they contained explicit documentation that particular surveys had been identified as fraudulent or unreliable. Records that directly connected specific current property descriptions to specific acts of fabrication. In 1926, the General Land Office ordered those files destroyed. The official justification in the published record was 4 words: useless papers, no value. 25 years of contested homestead records, gone. Useless papers, no value. Meaning the records of every family who had formally contested the federal government's description of their land for a quarter century. Records that in many cases documented specific, named fraudulent surveys. Records that would have made it possible, decades later, for a landowner or an attorney to trace a current property description back to a survey that had been internally flagged as unreliable or fabricated. Those records, the chain of evidence that connected a living landowner to a dead surveyor's fraud. The mechanism of accountability the original system had been designed to create and preserve. Incinerated. The Resurvey Act of 1909 authorized the federal government to restore obliterated corners. Any original corner whose monument could not be physically located in the field. Obliterated corners. The official term in the General Land Office Manual of Surveying Instructions, meaning someone removed the monument, or it had never been set, or the man who was contractually obligated to set it had filed notes claiming he did, and then cashed his mileage payment and moved on. This sounds like a technical correction process. In the abstract, it might have been. But the authority to determine which corners were obliterated and which resurvey method to apply rested with the Secretary of the Interior, whose conflicts of interest had been documented by his own department's investigators, suppressed, and then cleared on a party-line congressional vote. The surveys being resurveyed were in territories where, as the Benson investigation had established, a substantial portion of original surveys may never have been conducted at all. The records that would have allowed anyone to identify which specific corners in which specific townships were affected by the fraud were destroyed a decade and a half later. Which boundaries did they restore? Which survey served as the baseline for reestablishment in the townships where the field notes were apparently negotiable? I have looked for that answer in the archive. The destroyed records are the answer. Their absence is the answer. Before I close this file, drop a comment and tell me which part of this you're going to go verify first, because all of it is sitting in a public archive. Most people will never read it. You just did. Your deed references a survey. The field notes from that survey may still exist in Record Group 49 at the National Archives, or in the Bureau of Land Management's General Land Office Records database at glorcords.elm.gov. Publicly searchable right now tonight, no credentials required. Pull up your township and range. Look at the date the survey was filed and compare it to the date the field notes say the deputy surveyor was standing on your land. Look at the terrain description and compare it to what you know about your ground. In most cases, you will find a consistent, professional document that matches the landscape it describes. In some cases, you will find something that does not add up. A survey date that is a meteorological impossibility. A terrain description that does not match the topography. A corner location that corresponds to no physical feature that should have survived. Compare that terrain description to the section on Benson we covered earlier. Ask yourself whether a man who never left the office could have produced the notes you are reading. And in the cases where you find that mismatch, and you want to know what it means, and you need the homestead contest records that would tell you whether anyone else ever raised that same question about your specific parcel in a federal hearing room, those records are gone, not lost, not misfiled somewhere recoverable. Ordered destroyed in 1926 and given 4 words of justification in the official record. The question of whether the line on your deed was set by a human being who stood on your land is, for most rural landowners in the American West, a question the archive can no longer fully answer. Not because the truth does not exist somewhere in the historical record, because in 1926, someone decided that 4 words were sufficient to make sure it could not be found.